If you've been released and have to go to court on a DUI charge, you need a criminal defense lawyer who knows how to get results and make sure you're treated fairly. A lawyer who is knowledgeable about Georgia drunk driving laws. You should speak to someone who handles DUI cases all the time. In fact, you should consider talking to several different lawyers before you decide. You want a lawyer who will provide the strongest possible defense in a DUI case. Experience matters. I am Harvey Siegel, and I am not just a lawyer, I'm a DUI lawyer. In almost 30 years in the legal profession, my office has handled over 10,000 DUI cases. Let's take a look at what's facing you if you're convicted of your DUI when you go to court. First, you'll pay a fine. This will be somewhere between $600 and as much as $6,200. Second, you'll serve a jail sentence. This can be as little as 10 days and as much as 1 year to serve. Third, you'll lose your driver's license. This will be for either 1 year, 3 years, or 5 years, depending on your past driving record. Your car tag may be reclaimed by the state for a period of 5 years. Community service, somewhere between 80 hours and 240 hours of public service work. This can include picking up trash, working in a hospital emergency room, cleaning up City Hall, and so forth. You'll undergo a mandatory attendance at a DUI school. You must pay for, attend, and complete the school, and then pay to have your license reinstated after the suspension period is over. You'll have to undergo an alcohol evaluation and follow any recommendations they make for treatment. When you do get your license back, you may be ordered to pay for the installation of an interlock device on your car. You won't be able to drive the vehicle without breathing into the device first. You'll be ordered to serve 12 months probation. You must be on probation for a minimum of 12 months and possibly longer, and you must pay for this probation. Your name and picture will be published in the newspaper, and yes, you must pay for this also. Of course, your actual sentence will depend on many factors, including the judge who actually hears your case. Judges are people too, and they vary widely on their views and attitude towards drunk driving. Also, your previous driving record and the circumstances of your particular arrest will have a large effect on your actual sentence. In addition to these costs and penalties that are assessed in the courtroom, there are hidden costs that may follow you for years. Auto insurance cancellation, or outrageous rates if you can get insurance. Lost employment and future lost employment opportunities. Security clearance problems. Problems with the military if this applies to you. Yes, the costs can follow you out of the courtroom and down the road for many years to come. Let's shift gears for a moment and talk about something very important and immediate to you, your driver's license. You may or may not have heard about the 10-day rule. When you were arrested and charged with DUI, one of two things took place. First, you took a breath test and failed it. Or second, you refused to take a breath, blood, or urine test. In either case, the police officer was required by law to suspend your driver's license and give you a 30-day temporary permit to drive on. This gives you 30 days to get your affairs in order before the license suspension actually goes into effect. That's a 1-year suspension. You may ask yourself, how can they suspend my driver's license before I even go to court or am convicted of a DUI? Well, the answer is simple. They can. That's the law. Day rule. They're hoping that you'll be scared and that you'll fear the unknown. They're hoping that you'll sit back and do nothing, or simply wait for your court date, which means the 10 days runs out and they can chalk up one more DUI suspension without any additional expense or effort to the state. Is there anything you can do about this? Yes, but you have to act quickly. You have 10 days from the date of your arrest to request a hearing. If it is done in a timely manner and written properly, this will stop the suspension and give you your day in court. If it's not, your license will be suspended for at least 1 year. and maybe longer when you actually go to court for your DUI case. My office files these letters every day. We know what it takes to stop your license suspension and what to do when we go to court to keep your license in your pocket, not the government's. You only get one shot to stop your license suspension. If the time runs out, or the letter is not written properly or delivered to the proper location, your driver's license is in the trash can, and you'll be walking for quite a while. There should be something you can do to avoid facing the hard, cold treatment of the courts alone. The advice and guidance of a lawyer who is specially trained in this area could spare you the unknown and unwanted treatment awaiting you in the courtroom. We understand that you may feel powerless, and you may be afraid about what could happen to you when you do go to court. Being accused of a serious crime is very difficult for anyone. Just the process of being arrested, taken to jail, fingerprinted, and photographed is tremendously dehumanizing. But it's happened, and right now you need to ask yourself a couple of questions. First, do you know how to defend yourself when you go to court? And second, can you find the right attorney to help you without guessing? We will discuss all the alternatives open to you regarding your case. We will carefully discuss each and every legal option at your disposal, letting you know what the score will be before you go to court. We concentrate our practice in DUI defense, period. It's the only thing we do. We're always focused on developing new legal defense techniques to best protect and defend our clients' rights in DUI cases. When we take DUI cases to trial, we use every possible legal defense available to beat them. We vigorously attack field sobriety tests, and we know how to cross-examine police officers and to establish the flaws in these so-called tests. We know these tests well. We know these tests backwards and forwards. We know them better than some police officers, so we can spot their mistakes. This is critical to a good defense. We will use our expertise and knowledge of Georgia DUI law to fight for your rights. Finally, what will this cost you? Well, naturally, everyone's case is different. Everyone's criminal history is different. All the circumstances of your arrest are different. Thus, the cost depends on the difficulty and complexity of your case. Our fees are reasonable and convenient payment plans are available. The first office visit is provided to you at no charge. This gives you and the lawyer an opportunity to fully discuss your case without any financial pressure or obligation on your part. If you'd like to set up a free appointment to go over your case, you may call now at 404-525-1000. You may call now. Someone is waiting to take your call. You may call at 404-525-1000 for your free office visit. We've assembled some helpful information about what happens when you're charged with a drunk driving offense in Georgia. Use our website at theduilawyers.com. That's theduilawyers.com to educate yourself about what an experienced DUI attorney can do to help you. And when you're ready, give us a call at 404-525-1000, and I'll be happy to consult with you on the specifics of your case. There's never any obligation when you call, and the first office visit to go over your case is always free. Call us at 404-525-1000. Someone is ready to take your call 24/7 and discuss your case with you. We pledge to doggedly defend your rights, and remember, the initial consultation is absolutely free with no obligation. Call us at 24 hours a day at 404-525-1000 and tell us, "Help, I've got a DUI. What do I do?"